You brought a lawsuit against your doctor claiming that he was careless and that his carelessness was a cause of your injury. During the course of your lawsuit, now your attorney enters into settlement negotiations with the defense. And guess what? The defense gives you every single thing you're asking for, with one condition. You want to know whether that one condition will change whether or not you accept this offer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. Okay, you brought a lawsuit claiming that your doctor was careless, causing you significant harm and injury. And now your doctor denies all of your allegations. During the course of your entire lawsuit, you can't believe in your mind that the doctor is denying he did anything wrong. You can't believe that the doctor is saying that even if he did something wrong, whatever he did not cause or contribute to your injuries. And then you're shocked to learn that the doctor says, listen, even if I did something wrong and I caused you harm, your injuries really are not as bad as you claim them to be. So you are outraged, you are furious, and now your case goes through the litigation process. Okay, as you complete the litigation process known as discovery, and now your case is put on the trial calendar waiting for a trial date, guess what? Your attorney enters into settlement negotiations with the defense lawyer. And over the course of the next few weeks, there's back and forth between settlement demands and settlement offers. Finally, at the end of the negotiation, you learn that the defense has offered you every single thing that you have asked for, the amount of money that you have asked for, with one condition. The one condition is you don't tell anybody about this settlement. So what do? Do you go ahead and say, okay, I'll take the money, I'll live with that one condition? Or do you say, under no circumstance will I accept that condition? My intention once I settle this case is to go ahead and tell the world, tell everybody I possibly can about what a horrible doctor you are, what you did to me, what injuries you caused to me, especially when you refuse to accept responsibility for what happened. How dare you? And in that instance, you choose not to accept the doctor's one condition on settling this case for the full amount that you have asked for. Do you do that? The answer to that question is not so easy. Why is that? Because there are some instances where it may be beneficial for you as the injured patient to simply agree not to go ahead and tell anybody about your settlement. You don't want to tell your friends, you don't want to tell your family, for fear that people will now start coming out of the woodwork and asking you for money. So that may be one reason why you don't want to disclose that information voluntarily. The key reason why the defense doesn't want you to go ahead and disclose all that information and create a whole big publicity stunt is because they don't want publicity that is unfavorable for the doctor. They don't want it to happen because the insurance company represents the doctor. They don't want to see him have bad publicity. They don't want other attorneys who have similar clients with similar injuries, especially against this doctor, to be able to say, hey, you settled Oginski's client's case for this amount of money. My client's injuries are so much worse. Therefore, you have to give us so much more money. That's another reason why they don't want you to go ahead and disclose this information. If you can live with that restriction, then you go ahead and say, listen, I'm willing to live with that restriction and not tell the world about what happened to me and the settlement that I received. On the other hand, if your intention is to tell the world about everything that went on, you will likely have to reject the defense's offer and will likely have to go all the way to trial. Now, here's something interesting. When your case goes all the way to trial and a jury reaches a decision about whether or not you are slightly more likely right than wrong than what you are claiming is true, and the jury finds in your favor, now that verdict is public. You can go ahead and tell the entire world about that particular verdict. You can tell the world about the facts of your case. You can tell them about the defenses that the doctor raised in the case. You can tell them about testimony that happened. You can tell them about each element that the jury decided in your favor. Since it is a public record, now you can go ahead and disclose that to anybody and everybody that you want. So why do I share this great information with you? I share it with you just to give you a sense of what really happens in these medical malpractice cases in New York. You know, I realize you're likely watching this because you want to see the beautiful scenery behind me. No, I understand that's not why you're watching, but instead, you're watching because you likely have questions or concerns about your own matter. Well, if your matter did happen here in New York, but you have not yet started a lawsuit because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to talk to you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.